9. Welcome to all of our guests and esteemed panelists. Thank you so much for your time today and for joining this important conversation, navigating the future of racial justice and appellate law. My name is Salma Rizvi, and I serve as the president of the American Muslim Bar Association, a conglomerate of Muslim and non-Muslim attorneys who are seeking to use their power in the field of law to speak truth and build more peaceful and just institutions in America. AMBA decided to organize this event because both our practitioners and community members have expressed a total lack of confidence in the current makeup of the US judiciary. So much so that certain progressive civil rights organizations refuse to co-sponsor events with US federal judges, believing them to be part of the broader oppression of our US justice system that afflicts injustice against minority communities and communities of color. Meanwhile, we are taught a narrative starting from grade school that executives and legislators representing the whims of one faction of society or another come and go, but are put in check by the process of judicial review, the final vanguard of constitutional rights. In the United States, the judiciary is often thought to be the protector of justice. In reality, we have usually found the exact opposite of this narrative, with the judiciary serving as a conservative force that prevents the greater realization of the founders' egalitarian ideals and spoiling any gains made for justice from other divisions of the government. In fact, after Marbury established judicial review in 1803, its first use to strike down a state statute was Fletcher v. Peck in 1810, where the court unanimously ruled to validate a notorious real estate scandal which stripped the lands of the Yazoo Nation and set a precedent for the ongoing disposition of Native American lands. Gains in equal justice protections provided by the massive 14th Amendment are hamstrung by the separate but equal rulings. Then the first act of judicial review that the Supreme Court exercised affecting a federal statute was Dred Scott in 1857, which effectively excluded Black Americans, both slave and free, from exercising their rights to American citizenship as enumerated in the Constitution. Progress and justice made by one era of the court often sees itself reversed by the next generation, calling into question the myth of the judiciary being free from the transient movement of factions. This is even seen today, even as recently as a few weeks ago with the Supreme Court's recent decision in Jones, which essentially gutted precedent, as Justice Sotomayor mentioned, and has now reversed progress in the realm of juvenile rights. We further know that any attempts to change our judicial system by communities of color are somewhat bleak. If you are a minority who seeks a position on the bench, chances are that at some point in your career, you committed to doing equal justice work on behalf of the downtrodden, the voiceless. We have seen during recent judicial nomination hearings that such activism work can be used as a tool to diminish rather than to support a candidate's nomination to the bench. And most judges of color who are being appointed in recent years have done little to actually advance the rights of minorities and have instead served as advancing the powers of already powerful white-led institutions in America. Furthermore, appellate litigators who are passionate about their clients and the impact litigation that they are bringing forward either in the Supreme Court or Court of Appeals are asked to temper their behavior, to seem less like a trial attorney and be almost muted in terms of advocacy. It is as if racial justice advocacy at the appellate level must be silent of culture or passion in order to make an impact with appellate judges. Some litigators are told to speak white or appear in a different way in order to curry favor with certain judges. All of this personifies the lack of true diversity on the bench. Even if the bench is more colorful than in years past, there is no guarantee that a judge of color will necessarily be more sympathetic to minority appellants or appellees. We have seen that identity politics are no longer an adequate medium for assessing whether progress or change in a system is made. For all of these reasons, I'm excited to learn from our esteemed panelists today on how we may be able to enhance racial justice and the rule of law in future years. To begin, we have the Honorable Judge Theodore Mckee. Judge Mckee was sworn in to the U.S. Court of Appeals for the Third Circuit on June 20th, 1994, and became Chief Judge on May 4, 2010. He graduated magna cum laude from Syracuse University College of Law in 1975, where he was inducted into the Order of the Coif and earned several honors for outstanding academic performance. He began his legal career at large at a Philadelphia law firm, but left there in 1977 to begin his career in public service. He has since been a U.S. attorney, deputy solicitor to the Law Department of the City of Philadelphia, and general counsel to the Philadelphia Parking Authority. He was elected to a 10-year term as judge of the Court of Common Pleas for the First Judicial District of Pennsylvania. While a judge of the Court of Common Appeals, Judge Mckee chaired the Pennsylvania Sentencing Commission. He was appointed to the Court of Appeals by President Clinton shortly after being retained for a second 10-year term on the Court of Common Pleas. Judge Mckee serves on the boards of directors of several nonprofit organizations and institutions, including the Vera Institute of Justice and Syracuse University. He is also a member of the Board of Visitors of Temple Law School, an honorary member of the Board of Visitors of Syracuse University Law School, and has been an advisor to the American Law Institute's project to revise the sentencing provisions of the Model Penal Code. He also previously served on the Criminal Law Committee of the U.S. Judicial Conference. Most recently, Judge Mckee was appointed to serve as a member of the National Academy of Science Committee on Law and Justice. Judge Mckee's official travels have included Ghana and Russia, where he had the honor of addressing the Council of Russian Judges on the independence of the American judiciary. Welcome, Judge Mckee. Thank you so much for joining us.
Selma, thank you.
Vincent Sutherland joined the Center on Race, Inequality, and the Law as its inaugural executive director in 2017. As of July 2021, he will join the law school faculty as an assistant professor of clinical law to teach the Criminal Defense and Reentry Clinic and to serve as co-faculty director of the center. He has dedicated his career to advancing racial justice and civil rights. Vincent came to NYU Law after serving as an assistant federal public defender with the Federal Defenders of the Southern District of New York since 2015. Prior to his term at the Federal Defenders, Vincent spent 7 years at the NAACP Legal Defense Education Fund, LDF, where he was a senior counsel. While at LDF, he engaged in litigation and advocacy at the intersection of race and criminal justice, including the successful representation of people sentenced to death across the American South and children sentenced to life imprisonment without parole. He also led LDF's advocacy efforts around race and policing and was lead counsel in school desegregation and employment discrimination matters. Vincent previously served as a staff attorney at the Bronx Defenders and E. Barrett Prettyman Fellow at Georgetown University Law Center. He began his career as a law clerk to the Honorable Judge Theodore Mckee, who is on our panel today, and the Honorable Judge Pollock of the U.S. District Court for the Eastern District of Pennsylvania. Vincent holds an LLM from Georgetown University Law Center, received his JD from Temple University School of Law, and his BA from the University of Connecticut. He serves on the boards of the Bail Project, the Federal Defenders of New York, and the Center for Constitutional Rights. Welcome so much, Vincent. Thank you for joining us.
Thank you so much, Selma.
We also have joining us today Juvaria Khan, who is the founder and executive director of the Appellate Project, a nonprofit organization empowering law students of color to thrive in appellate law field. She clerked for the Honorable Michael Shia in the District Court of the District of Connecticut before joining Patterson, Bell, Camp Webb, and Tyler, LLP, where she maintained a heavy pro bono practice focusing on racial and religious discrimination claims. She then served as a senior staff attorney at a national legal advocacy organization where she successfully combined litigation and public campaign strategies in cases ranging from public accommodation claims to religious land use lawsuits. Juvaria is a graduate of New York University and Columbia Law School, where she was a Harlan Fiske Stone Scholar. Welcome, Juvaria.
Thanks for having me.
And last but not least, we have Alexis Karteron, who is an assistant professor of Law at Rutgers Law School, where she directs the Rutgers Constitutional Rights Clinic. The clinic engages in litigation and legal advocacy concerning a range of constitutional and civil rights issues, with a focus on issues concerning mass incarceration and the criminal legal system. Prior to joining the Rutgers faculty, Professor Karteron was a senior attorney at the New York Civil Liberties Union, where she litigated a variety of civil rights and civil liberties cases addressing police misconduct, the school to prison pipeline, the First Amendment, and criminal justice reform. Professor Karteron also completed the Fried Frank NAACP LDF Fellowship and served as the White House Associate Staff Secretary during the Obama administration. Professor Karteron is a graduate of Harvard University and Stanford Law School and clerked for the Honorable Marcia Berzon of the U.S. Court of Appeals for the Ninth Circuit. Welcome, Alexis. Thank you for joining us.
Hi. Thanks so much for having me.
Great. We'll go ahead and get started today and allow all the panelists to chime in. And then at the end of this moderation session and Q&A in about 50 minutes or so, we'll open up questions to the audience. In the meantime, if the audience does have any questions, feel free to send them to me or type them in the chat for everyone. I'd like to begin with Judge Mckee. If you could please share with us your journey of becoming an African-American judge on the U.S. Court of Appeals for the Third Circuit. Did you face racial obstacles in this pursuit?
You know, it's an interesting question. It's the last part of that I really can't tell. I don't know, because obstacles that are put in folks' way, there's no sign they're saying Black folks don't go this way or need not apply. It's more subliminal. And so, you know, I did not experience anything that I experienced as overt racial hostility. I experienced one episode which was not hostile, but it was kind of weird. When I worked at the parking authority, everybody at the parking authority at the time, I don't want to cast aspersions on the current employees, though I don't know if it's changed or not. This was quite a while ago. Everybody there was had political connections. They were a ward leader or a committee person or connected to a ward leader or committee person. And one of the reasons that I was fortunate enough to go there was because the then mayor understood they wanted to run for common pleas court, and I couldn't be politically active as a city solicitor. I could be, because it's a city agency, home rule charter prevents that. I could be politically active at the parking authority because it's a state agency, not a city agency. But anyhow, I remember one day a ward leader from a very conservative part of Philadelphia came in and says to me that he was going to support me for common pleas court judge, which what I was running for then. And then he said to me, you know, McGee, which he always called me, McGee, you're the first colored kid I ever supported for anything. So when he says, oh, geez, thank you. But then he said, you know, there's just one favor I got to ask of you. And I'm sitting there thinking to myself, shit, here it comes. The quid pro quo. I got, how do I tell him I can't do any favors, can't give any promises? He said to me, you know, you got to stay out of my ward meetings, stay away from my ward, which I was delighted to hear because I didn't want to go to his damn ward anyhow. And I said to him, I'll call him Sam. Sam, I have no problem with that. I'm fine with that. And I wasn't going to ask him why. I was just happy that I have to go to his damn ward. And he says to me, yeah, you know, McGee, we got a lot of Irish folks. He didn't call them Irish folks. He used an ethnic slur, you know, in my ward. And, you know, your name, McGee, I can pose you off as one of them. So as long as they don't know that you're a colored guy, I can get a lot of votes for you. And so I stayed away, and I got calls on election day from people who were running. In fact, the mayoral candidate called me that day and said, Ted, I hear that Sam's carrying you all day long in his ward and his sample ballots. What the hell's going on? I just said, hey, you know, geez, I don't know. I guess he's impressed with my credentials and my academic performance. but that was the only time that race really overtly came at me. And it came at me in a way which helped me in a roundabout kind of backhanded way. In terms of the obstacles, you can't tell. You know, and my guess is that everybody on this panel has been in the situation where you just never know if what's coming at you is a racial slight, age slight, geographic slight. You can't tell. So there may well have been other obstacles there. I suspect, given the prevalence of subliminal racism, that there probably were other obstacles that are based upon race or related to race. But the only one I can specifically tie to that is my little discussion with my buddy from Northeast Philadelphia.
Thanks so much for sharing, Judge. That's a beautiful story. And I remember when you first told me that story, it put into perspective how to think strategically about one's career and not allow these certain moments in time to really affect us. And I really admire the way that you were able to think on a long-term scale when that happened and just go with the flow. Yeah, thank you so much for that beautiful story and the lesson associated with it. And Vincent, I'd love to ask you the second question. I'd love, particularly for the members in the audience, for you to define racial justice if you can, and please share with us your journey of what led you to commit to the pursuit of racial justice full-time in your current role.
Sure. And, I'm really thrilled to be on this panel with such great folks, especially with Judge Mckee, who I clerked for. And I have to say it was probably the pinnacle of my career, even though it was my first job out of law school. When you ask me to define kind of racial justice, it's a really difficult thing to define in some ways. But I think in the broadest and probably simplest terms, for me, it means the end of oppression and marginalization on the basis of race. So that's the end of institutional and systemic racism, the end of the type of racial hierarchy that we have in this country that's fostered by all these institutions and systems that have really supported and perpetuated this racial caste system we have in America. It's a collective commitment, I think, that we can all live freely, regardless of our identity, regardless of the color of our skin, regardless of where we come from and who we are. And it's really about kind of doing the work of addressing the systems and structures and institutions that have harmed us along these racial lines, really since the inception of this country. I think it transcends equality and really speaks to something about liberation and freedom. And I think it begins with a collective acknowledgement of our racial past and an understanding of the way in which that past shapes our present and will continue to shape our future if we don't work to disrupt it and disrupt the influence of it. It's a collective commitment to repairing the harms of that past, harms that have really visited racial inequality upon all of us, to never let those harms happen again, to repair those harms and recompense those who have suffered those harms, and to really build systems and institutions and structures that are infused with those types of goals in mind. And for me, this journey on trying to advance racial justice throughout my career really started pretty early on. I grew up in Connecticut, in a city called Bridgeport, Connecticut, which is largely Black and Latino. And when I was in about fourth grade, moved from there to a small town called Beacon Falls, Connecticut. As you might guess from the name, Beacon Falls is not a very diverse place. I went from being one of many to one of very, very few. In fact, the only child of color in my elementary school. And that brought with it a bunch of culture shock. It also brought with it kind of a consciousness about the way my own identity shaped not only the world around me, and shaped the way that people would respond and react to me, but shaped how I'd walk through the world, and had a lot of kind of interpersonal interactions with my classmates, a lot of fights and arguments and a lot of battles back and forth. Also got a lot of support from folks who even at that young age saw the kind of rank unfairness of it all. And then fast forward even a couple years through my elementary school career, I guess, in 1991, I was about 13 years old when Rodney King, a Black man, was beaten within inches of his life by the LAPD. It's very much reminiscent of the types of shootings and beatings and police violence that you see against Black and brown people today. But this is one of the kind of real, for me, flashpoints. And it really, connected with all the things that I was feeling and seeing in that transition from a place where I was, like I said, one of many Black and brown kids to one of a very, very few. And it spoke to me about the ways in which these systems that are governing our lives would treat people of color, particularly Black people. And then a year later, seeing the police officers who were caught on tape beating Mr. King be acquitted in the court. Although they were eventually convicted in federal court, you know, the LA riots and LA uprisings happened shortly thereafter. And I think it was at that point that I made a commitment to really focusing on trying to change the course of at least the ways in which racial inequality was playing out, you know, from my vantage point, and really decided this is kind of the work that I wanted to lean into and dig into and see how I could, you know, join the ranks of all those throughout history who've fought this fight and fought these battles, both the names of those who are famous and the names of those who we don't know about at all, or our parents or families and other loved ones who've come before us. And so that was kind of an awakening for me. And from there, it was kind of off to the races, so to speak. And I really focused on racial justice for the rest of my career, and you know, don't plan on changing focuses at all going forward. So that was really, I think, what brought it all home to me. And I think it's, quite frankly, one of the things that kind of gives me a little bit of hope about what we saw last summer, is that, you know, there may be young people out there, and they don't necessarily have to be young people, but people out there who saw all that injustice unfold, saw George Floyd having life choked out of him by those police officers, were shocked and outraged and angered by that, and want to do something about it. And you know, that's how I ended up on this path and on this journey. And I'm hopeful that will be the case for others. I think it's going to take all of us to do that work.
Thank you so much, Vincent, and thank you for your strong voice last summer when the protests were happening and there were so few academics who were willing to speak to press about the situation from a legal perspective, and you were using your voice to speak truth to power. So thank you so much for continuing your great work. And you know, your remarks about the past and the future and how we have to keep working leads into my next question for Alexis. As a civil rights impact litigator, I'd love, Alexis, for you to talk a little bit about how impact litigation can support the pursuit of racial justice, and how do we convince impact litigators to engage our current judiciary without the fear of making bad law?
Yeah, thank you for that question. I started law school just about 20 years ago this year. And it's a question that I think people in the civil rights community have been grappling with for that entire time. I remember going to panels like this when I was a law student, and people were talking about the same questions. And I think, to be perfectly honest, there's probably not a really great answer. I think, you know, the courts have only gotten to be more conservative in those 20 years. It only has gotten, I think, a little bit more scary to be going to at least federal court to vindicate the civil rights of people of all hues in the United States, but particularly people in marginalized communities and Black and Brown communities. So I think the fear is real, and you know, there's good reason for the fear. And luckily, there are incredibly brilliant attorneys at places like LDF and the Center for Constitutional Rights and other organizations that are grappling with these questions all the time. And I think, you know, sometimes it's about building coalitions. You know, it's thinking about, you know, what are the issues where you think you could have a fighting chance, even if you say draw a conservative appellate panel. You know, sometimes it's kind of a game of chance, you know, knowing that the Supreme Court really takes very few cases. They really just don't take that many cases. So, you know, when you're putting together a case, the chance that your case is going to be one of the ones that makes it all the way is pretty low. But of course, that's not true when you're talking about the federal courts or the federal appellate courts generally. So I think it would be, frankly, malpractice to not think about that and not consider that risk. So, you know, issue by issue, there has to be some thought put into what kind of game are we playing here? What kind of risks are there down the road for communities that are already marginalized and already vulnerable? I think another thing to keep in mind too, though, is that not all courts are federal, and not all courts are being stacked with extremely conservative members who are hostile to impact litigation that advances racial justice. And so looking into state courts is also sometimes a really valuable approach. And I'm at Rutgers in New Jersey. And for a very long time, there's been a lot of litigation, impact litigation, that's been brought in the state courts because they've been viewed as, frankly, a little bit more of a friendly venue than the federal courts. No offense, Judge Mckee on the Third Circuit.
Not quite all right.
So, I encourage people to think about, when you're in law school, there's so much emphasis, and we're all trained in this way. I think there's so much emphasis on the Supreme Court and on federal appellate courts, but of course they are not the only courts. Getting a victory in impact litigation at state court can still affect tons of people. In New Jersey, we're roughly 9 million strong, but there's also California, 50 million people. And getting victories at the state level can be incredibly valuable as well. But it's, like I said, it's a great question. It's a perennial question. It's a question that I've heard people attempt to answer on panels for 20 years, which is hard to believe. And I think it's one that we have to keep asking ourselves. We have to keep challenging ourselves to think about, are we bringing this case just because we like the idea that we really think, a federal appellate court or the Supreme Court should do this because it's the right thing to do? Or are we bringing a case that we think actually really has a chance of success, that can really, help us achieve some social justice end?
Thank you so much, Alexis. Yeah, it's a really tough question, and it's really hard, particularly I feel, the appellate litigators, I know this in the last 5 years, who almost have PTSD from litigating certain cases that have come back, and that it's the weight and the responsibility of feeling that this bad law you've created across the country now, or across the region, is the responsibility of you trying to be courageous and bring your litigation to the next stage of review. And so, yeah, there's so much work to be done there, and I'm hoping, that could change, and over time in future years, appellate litigators can feel a little bit more comfortable as we continue to try to strive for change on the bench, which leads me to, and with litigators themselves, which leads me to Juvaria and the Appellate Project and all the great work you're doing. And I'd love for you to talk a little bit about what the barriers are to accessing appellate work, and to share with us your journey of what led you to start the Appellate Project in the US.
Sure. So I did not know any lawyers growing up. Appellate work was definitely not on my radar. My first understanding or exposure to the law was because of 9/11. I grew up in rural Arizona, and 9/11 was a very dramatic and seismic shift for the community, the Muslim community I'm part of. FBI visits, getting detained at the airport, of course, the harassment. All of that kind of got me interested in who was creating these laws. And, clearly they'd never met anyone from my community. And that got me interested in civil rights work more broadly, and learning about how other marginalized communities had advocated for their rights, including many of the rights that my community does have through the legal system. And so that interest led me to law school. Law school was it was challenging, and for the wrong reasons, I would say. I felt so out of place. It often felt like a lot of my classmates came in with these networks or this savviness and just knowing how to navigate these spaces. Their parents or their family friends, their networks that they were part of, inform them with resources and knowledge on how to navigate and get to A to B. And so much of, I feel like, law school and just the early part of my career was feeling quite lost. When I finally got meaningfully exposed to appellate work, that was through impact litigation. That was kind of what I had always wanted to do, and focusing on issues impacting the Muslim community. And what really struck me was two things. One, I had spent most of my career before that doing trial work and was just blown away by how much more I enjoyed appellate work, just the rhythm of it, and kind of wish someone had just sat me down before and explained it was an option. I think I would have made a lot of decisions differently, which is part of the reason for starting the Appellate project. But beyond that, it was what appellate work entails. To borrow from Amir Ali, who's one of our board members, it's like you're playing a game of checkers and then realize there's a game of chess. And appellate work is deciding matters of law. So it's a conversation between these attorneys and judges on what our laws mean and how they apply to all of us. There are no juries in these situations. You have appellate attorneys who are shaping the arguments and deciding which facts are presented and how. Not infrequently, they go on to become, join the bench themselves or other prestigious positions where they're influencing policy. And then, of course, judges are engaging in this deliberative process with each other. And when you have a group that is largely homogenous in their networks and their background and their race and their gender, everything, you miss the lived experiences and perspectives that communities of color bring. And you see that reflected in the law. And just seeing that again and again was very frustrating and made me kind of think about my own journey and that of so many colleagues of color who often are first generation and, don't know kind of what the game is. You don't know what you don't know. So you miss out on a lot of steps. And so all of that is what made me kind of take a step back and think, is there a way to address some of these systemic barriers? And, so much of appellate recruiting and hiring is a handful of law schools, a handful of students at those schools who have connections with the right professors or judges to get them in the space. When it's set up that way, you're obviously excluding a lot of very highly qualified students who would be great at this work. So our programs are really aimed at trying to broaden that access and ensure that all highly qualified students are considered for these positions and have the same resources to do this work.
Thank you so much, Juvaria. Yeah, thank you so much. And thank you for starting this project and for all of the momentum and movement you've built this past year. It's been amazing to see. And I really do hope that the appellate space changes both in not just the bench, but also those who engage this appellate litigation work. And I'm hoping, and I know you've already been making great change in that way through the Appellate project. So thanks for what you're doing. I'd love to kick it back off to you, Judge Mckee. And if you could talk a little bit about what common challenges are that you observe that disadvantaged communities face when litigating at the appellate level, whether that's immigrants or the Muslim community or the Black community, if there are any certain challenges you observe that they come up against when approaching the Third Circuit or
Yeah, I think before I answer that, this is an important question. I just want to take 10 seconds to amplify what I said earlier about my experience at the parking authority, because it dawned on me, it may sound like basically I was given a no work job, but the parking authority was moving from off-street parking only, which is what historically had been empowered to do, to on-street parking under a change in state law. And that required that for the first time they have an in-house counsel. They never had one before because there had to be things drawn up for acquiring certain equipment, uniforms, tickets, property. And there had to be ordinances enacted and proposed to city council and statutes. So that was the reason the mayor thought that I would be a good person for that. In terms of changes, impediments that come up for disadvantaged communities, it's the law is so circumscribed in terms of what judges or anyone else can decide, because the vast majority of our cases are decided by clearly on point precedent or clearly applicable statutes that really do not give any room for individual proclivities or individual views of fairness to enter into it. But there are gray areas occasionally. And I think in those gray areas, every judge, and I think a lot of judges may deny it, but this whole balls and strikes thing, which is a very unfortunate metaphor, which has been used to describe what judges do. And I can detail that if you'd like me to, why I think it's unfortunate and also misleading. Within those interstices, you've got to use something. If the law doesn't clearly dictate the outcome in terms of the precedent with the statutes, something is going to, whether it's a conscious something or an unconscious something, help you view the facts and the law and the application of the law. And that's where I think people's experiences come in. To the extent that certain disadvantaged communities have been devalued, not just disadvantaged, but devalued, their humanity has been called into question, if not stripped away. I think they have a tougher time having someone who's trying to be fair, because judges do try to be fair, um, have someone who's trying to be fair see their plight the same way that they might see someone who was more easily identified in terms of their humanity and who the judge could more readily relate to. Again, it comes up in sentencing. It comes up in the application of certain very um, ambiguous laws, ambiguous cases. It's a very, very narrow street. And it doesn't happen often, but it does happen. And I would submit to you that when it does happen, the sensitivity and experience of judges um, help guide the judge, even though the judge may not be aware that that's what part of the motivating force is. And to the extent that someone, an appellant, is in a position where they have not really been valued as fully as their majority counterpart, as and there's no research that I can think of specifically dealing with the question that way, although there's a ton of it, raising the question in a different context, especially in the death penalty area, that bears this out. In those situations, I can't help but think it's more difficult for the disempowered, I'll say. And that includes, I think, in many situations, to poor whites as well. It's not only a caste problem, it's a class problem as well. Getting these institutions to see their humanity and to treat them the same as they would someone who was not of a disadvantaged class or caste, I think is the challenge, and that's what we need to be aware of. And I would hope that's how my particular experience and approach and viewpoint may may help me reason through a particular situation. The same way that someone who doesn't have a similar set of experiences will be, even though they may not be aware of it, assisted in reasoning through the situation from a perspective where they may not understand that they are devaluing the individual and the individual situation.
Thank you so much, Judge, for that that amazing perspective and the discussion, particularly on humanity. And I guess some of that solution might lie in greater exposure for judges to have just with diverse, whether they're hiring more clerks of color or they're meeting, you know, diverse people through other initiatives. So thank you so much for sharing that. And I'd love to hear from, from your perspective as well, Vincent, as, you know, when you were litigating as a Black man, these complex civil rights cases in appellate courts with the LDF, what were your greatest challenges when conveying legal arguments?
Yeah, I think so. A lot of my time at LDF was spent in what was then their criminal justice practice group, and so a lot of the cases that I ended up litigating, were capital post-conviction cases. Many of them in federal habeas, although we did other matters as well. And I think, to me, some of the more difficult parts of that litigation, I think it fell into a couple of different buckets. I think first, overcoming what were often really difficult facts in those particular cases, where you had a client who had been convicted of a homicide, or a client had been convicted of some type of a crime. And my sense or feeling was that a lot of the judges that we were, appearing before or litigating in front of, despite the fact that their task and challenge is really to look at the way in which the law was applied and whether or not the law was applied fairly and justly and equally, I think it's hard just as a human being to overcome that initial revulsion about what someone did or what someone's accused of, and to help someone look at a case and think about the ways in which these legal principles are not going to just apply in this one individual's case, but they're going to be broadly applicable to a whole class of individuals, and so I think there was that piece of it, kind of separating out those challenges. And I think the other thing is something that Judge Mckee touched on, and others have touched on as well, which is, the law itself really builds and rests on precedent, and those precedents are often crafted in the context and by people with their own vision of how the world is and how it should operate. And if you think about a lot of the kind of precedents that we're relying on, they were crafted at a time when in some instances, you hear kind of Black Lives Matter right now, but Black lives are not seen to matter at all when some of these precedents were crafted and built. And so I think you're battling that kind of uphill battle, and I think you're also battling the fact that a lot of the members of the judiciary don't necessarily have the context or experience that would help them to align their worldview with the folks who are kind of dispowered, disfavored, the folks who were often at the receiving end of the most harsh treatment of the law. So if you think about the Supreme Court, I think Thurgood Marshall was the last person on the Supreme Court who actually defended someone who was accused of a capital crime, right? I don't think there's been a defense attorney on the Supreme Court in decades. The federal courts are very much inhabited by a number of former prosecutors, and there's nothing wrong with having former prosecutors on the bench. I think it's fair and just, and you should. But the imbalance is so steep and so tremendous that you often end up getting decisions and getting decision making that's taken from one particular perspective, one particular viewpoint. And I think kind of jarring people out of that perspective and viewpoint was another challenge that we often face when kind of litigating in front of these courts. I think there's a little bit of all these things that were in the mix in the context of litigation, and particularly in the criminal space, for certain.
So before we go on, can I just add one thing to that? I'm 99% positive that the statistic I'm about to give you is accurate. I've heard it a couple of times from several different people who would know. Vincent mentioned the disproportionate number of prosecutors on the federal courts, and I'm one of them. In the history of the United States, there have been exactly 5 public defenders appointed to the circuit courts, any circuit court in the country, 5. And that includes one of my colleagues now, Phil Restrepo, who I think was the 5th. Actually, I think the number is 4, but I'm trying to err on the side of liberalism. And that's in the history since the founding of the United States. And that just goes to show the how far things have gotten out of balance. His credit, President Biden is trying to make that a priority in terms of the diversity that he's trying to bring to the bench and looking for people who have experience the defense side, not just the prosecutorial side, but it really is out of kilter.
Thanks so much for sharing that, Judge. And I also see a move for different civil rights organizations, including the American Muslim Bar Association, to endorse candidates who are seeking nominations from their members of Congress to have a background in federal or public defense. And we're really trying to encourage those folks to try to compete for positions and nominations on the bench, and try to find ways in which we can support their endorsements through kind of, like Alexis was mentioning, that coalition building, which has been a really interesting process to learn about. But thanks so much, Judge. I had no idea the number was so low because you introduced Judge Restrepo, so I thought it was maybe more common, but wow. Wow. And Juvaria, I'd love for you to share with us, Vincent talked a little bit about the criminal justice context of this kind of appellate litigation. As a former Muslim advocates attorney, I'd love for you to talk about some of the unique challenges to racial justice facing Muslim minorities when you were doing your work as well.
Yeah, sure. I think a lot of the conversation around that focuses on post 9/11 work, but it's worth bearing note that Islam has been in this country since the first slaves were forcibly brought over, and Black Muslims have faced a litany of challenges since day one. And I think what's different since 9/11 is a lot of that discrimination was tied to anti-Blackness. And the way that we look at post 9/11 cases is often bringing in immigrant Muslims who are South Asian or Arab, but a lot of the communities who still bear the brunt of these policies that intersect between national security and race and religion are still Black communities, Black Muslim communities, Somali communities, for example, who are consistently subject to surveillance policies at the border and with countering violent extremism. And, I think you asked about unique challenges. And I think one of the things that I constantly felt was, how can you fight against a presumption that is considered valid, that an entire community is a national security threat, just off the bat? And when that's endorsed, both in public sentiment, but in our highest courts, and I think a very blatant recent example is the Muslim ban decision, right? And so it's incredibly disheartening to do this work and to see an opinion like that come down. And just to kind of give a little color to that decision, we're talking about the Immigration and Nationality Act. There's two provisions that were at issue there. One is Section 1182F that allows the president to bar, foreign aliens who are deemed detrimental to the national security interests of the United States, and 1152A, which is the non-discrimination provision of the INA, which says that you can't discriminate on the basis of nationality when issuing visas. That provision, if you look at the history, was passed because of the US history of having racial quotas on immigration. And it's, for a very long time, the only people who could become naturalized were white foreigners. And so with this change in policy, you would think that there would be more of a discussion of that by the Supreme Court when they say that, 1182 trumps over the non-discrimination provision, but there's not at all. And I think what was so striking about that decision.
Sorry, your audio. Is it all of our audios or echoing?
I hear it a little bit. I heard it a little bit with you just then.
It might be my internet.
Oh, okay. I think that's better.
It's better. But what was so striking about that decision was, the fact that the court could overlook the non-discrimination provision when the entire, Muslim ban was pushed forward by blatant discrimination against Muslim communities. That wasn't something that President Trump tried to hide in his campaign or while in office. And while the litigation was pending, he still had up on his website, complete and total shutdown of Muslims entering the United States. They only took that down when they got called out on it in one of the briefs. MacArthur Justice Center filed an amicus brief that Justice Sotomayor cited in her dissent, which highlighted some of the blatant discrimination that President Trump had voiced against Muslim communities. It's 36 pages and it's really explicit. I mean, how can you fight against that when there's all of that presented and you still don't get the benefit of the doubt? And I think for that case to come out in the same term that the Masterpiece Cake Shop decision is issued, it kind of underscores the challenges of doing that work in these spaces.
Wow, thank you so much, Juvaria, for bringing light to all of that. And I'm going to have to read that MacArthur report. Maybe you could send it and I can share it with all the attendees as well. Any sources any of you all would like to share, by the way, I'm happy to share it with the attendees and the registrants of this event. Thank you so much. And Alexis, I'd like to know from your perspective, particularly, we've talked a little bit about Judge McKee's perspective and challenges to, that that litigants face that come before him, his court, and Vincent and Juvaria talking a little bit about their challenges in doing some of this work on behalf of these communities. I'd love to talk to you a little bit about, as a civil rights litigator, what are challenges you face in accessing the clients themselves that are seeking to seeking support and seeking appellate representation. I know you've had some kind of process issues around this, and I think it's important that we pay attention to process and access issues when it comes to racial justice in our appellate court. So I'd love for you to share.
Sure. For me, my clinic is, as you said in my introduction, is the Constitutional Rights Clinic. And in recent years, we have tried to focus on work related to mass incarceration in a variety of ways. So not doing criminal defense work, which of course is vital, but really kind of working with people who are impacted by our criminal legal system at the margins. And so not within their criminal cases itself, but taking on policing issues, the enforcement of civil rights with regard to parolees, for example, and also people who are incarcerated. And so what I really love the most about this work is really, I see it as working with people who are the most marginalized, the most dispossessed, people who are very often, frankly, despised by many people in our country, in our society. And so I find that is incredibly valuable. People who don't have a voice, people who don't feel listened to very often. And then when they do get into, say, a court, as Judge Mckee mentioned, perhaps the judges are before lack empathy for them. So even though I find this work incredibly inspiring and valuable, these are also not the people who are necessarily able to access legal counsel easily. They aren't necessarily well educated and certainly often don't have a legal education that allows them to identify the legal boxes their issues might fit into very well. And so wanting to do that work can be a challenge just in terms of making connections with the people who need the help the most. And particularly people who, when you're talking about incarcerated people, obviously there are easily identifiable access issues. But then even people, on the outside, people who, again, have maybe some kind of bad interaction with police or in community supervision or something like that, can often be extremely vulnerable, have a lot going on in their lives. And frankly, there aren't a lot of people who are beating down their door to offer their legal services to them. So one of the things that I've been trying to do in my clinic is, reach out to people if they haven't come to me themselves, to really find people who are kind of organizing on their own to identify the issues that they find to be the most pressing, and provide some kind of legal assistance for them. And, I would say, for example, I hope in the next year to be doing an appellate case in the Third Circuit. And, it's not always easy to, certainly not always, it is rarely easy, if not impossible, to kind of navigate a federal appellate court if you don't have a lawyer, but getting connected with one can be extremely difficult. So, one thing that I've been thinking about is how courts make it easy or hard to access counsel. Putting aside whether courts are accessible for people who are pro se and operating without lawyers on their own, but just connecting people with counsel and really actively trying to facilitate that, I think is something that's so important and could really benefit from more attention.
Thank you so much. Thank you so much, Alexis. Yeah, and I've heard this critique and criticism from appellate litigators, whether they're working in big law or have their own practice, that are trying to get on CJA panels at the appellate level and are having difficult time, or trying to access pro se litigants that are in federal prisons that might have really robust civil rights claims, but their pro se briefs just will not cut it without that representation. So I think it's important definitely to note and to talk through these various circles of how we can make these processes more easy, the linking between appellate litigators and those who would benefit from litigation, but just don't have the right linking and the access. And maybe some of that's the responsibility of the court, and some of it's the responsibility of others who are involved in this work to push the court to make processes more simpler. So thank you for sharing that. And I'd love to ask Vincent, kind of pigging back off of that, do you feel, particularly as a former federal offender, did you feel that the federal judiciary system was designed in a certain way to incarcerate people of color? And how do we combat this reality if you feel that there are racial undertones kind of implicit in the way our system operates federally?
I think undertones maybe is an understatement in some ways. I have to say, I felt that way from the very point I started working in the federal and state criminal system. I don't think that the system itself is broken, but I think it's really working as it was designed from the beginning as a tool of racial control and social control and to keep people in their place. And that's not to say that the system has not evolved over time, and real harms certainly do come to people and are certainly perpetrated by folks who are caught up in the criminal legal system. And so I think both things can be true, but I think if you look at kind of the origins of our country, the ways in which we perpetuated enslavement, the ways in which we ensured that and propped up segregation after enslavement ended, all those regimes were really enforced by the criminal law and enforced along criminal lines. And so you were punished if you drank out of the wrong water fountain, right? You were criminally prosecuted if you gathered and put in a particular place with a particular group of people. When you think about enslavement, in some instances, it was a state being very explicit about using the criminal law to support that system. In other ways, it was basically implicit, and so there was no punishment if you killed a Black person because that person wasn't considered a person; it was considered a piece of property versus a white person, and some harm might come to them. So I've always kind of felt that way, that we've so kind of infused race and criminality and fear and dangerousness and punishment that it's almost become inseparable. In the federal system, I don't know, and I wouldn't say that that judges or prosecutors or law enforcement were explicitly or overtly racist, but I think we have a system that's kind of set up that way, and it's a repository for all the harms that have come to folks in all the systems that have failed them before. And when we think about kind of how do we combat that reality, I think the task is comes up on multiple levels. I think part of it is trying to dismantle the system that we have and dismantle the parts of it that are the most harmful and that are doing the least to actually ensure some measure of public safety for everyone. And think about how do we reinvest in communities and reinvest in people to help repair those systems that are actually funneling people into the criminal system in the first place. And I think the other piece of it is kind of cultural. And I say that because I think we have to really work to disrupt and eradicate this narrative that is so closely in our minds tied Black and brown skin to a presumption of criminality and a presumption of dangerousness that makes it easier for us to throw certain people away. It makes it easier for us to punish certain people because of who they are, rather than to kind of think about the context that brought them into a situation in the first place. So I think, that work is I think been ongoing for centuries, and I'm sure it will continue to go on long after I've stopped practicing and it remains to be seen kind of what success will grow out of it. But I think that's the type of work that we really have to undertake in order to kind of change the paradigm around the way these systems operate and figure out other ways to hold people accountable for the harms they might have perpetrated, and to heal those who have been harmed. And in those other instances where it's not person involved in a particular harm, what are the things that brought somebody into the criminal system, and how do we direct our attention and resources and energy to those particular things? Because right now, I think we're just warehousing people without any real plan for how to resolve those more deep-seated concerns.
Thank you so much for sharing that and really reminding us of the role of disruption, particularly as lawyers and litigators, and even those on paths to, becoming appointed, whether that's U.S. attorney or a judge one day. I think the idea of disruption is not promoted or supported so boldly as how you're saying it now, but it needs to be, and we have to really call into question the way things are and have been for so long. And thank you so much for sharing. And Judge Mckee, sorry to put you at a spot, but as a member of the system, as a judge on a federal appellate circuit, we'd love to know what your role is in that disruption, particularly, what is the role, if any, of a federal appellate judge in achieving racial equality? And do you think that as a Black man on the U.S. Court of Appeals for the Third Circuit, that your diverse voice has had an impact on matters related to racial justice?
Several questions. As to the last part, I don't know. And to the extent that it may have had an impact on matters related to racial justice, I'd hope it also has an impact on matters related to gender justice, to worker and employee justice, to just basic fairness. To the extent that it's had an impact, I don't know what I'm trying to do. And there are very, very few situations where this happens, very few, where I really feel my presence on a panel has made a difference. And I've had this conversation with myself for years now, and I sometimes have with my law clerks and colleagues when we get together. We often have this discussion because of what I said before, because our outcome is usually governed by controlling precedent or unambiguous statutes. In the vast majority of cases, there is no room for discretion or personal feeling or sympathies to come into play. In the few cases where there are, then I'd like to think that I've had a difference. It made a difference. I remember many years ago, I had a black lung case. I haven't seen one now in 10 years. When I first came in the Third Circuit, maybe a third of our docket were black lung survivors cases and black lung benefits cases. And there was a case where there was a woman whose husband had died ostensibly of a heart attack, but it was clearly caused from exposure to years in the mines. And he had been receiving black lung benefits while he was alive. And I was able to convince the panel that the fact that the death certificate said he died of a heart attack did not preclude the fact that the heart attack was hastened by, if not caused by, all those years working in the mines. And unfortunately, one of my colleagues, his son was home on winter break from med school, and he heard the oral argument. The next day, I got a call from that judge who was sympathetic and was somewhat persuaded in the oral argument in the conference. But it was a 2-to-1 vote, but I had the majority. But the dissenting judge called me and he said, Ted, geez, I think you're absolutely right. My son was in the audience yesterday. He's a intern now, and he specializes in pulmonology. He said, you're absolutely right, that there's no way the damage and the trauma to the lungs from the coal dust would not have hastened, if not caused, the heart attack. And in the way the opinion was worded, so we sent it back for an award of benefits, and we specifically said that the award benefit, the amount of benefits had to be determined within 35 days from the date of this order, because the agency had a history of deferring and delaying until everybody was dead. And we had criticized them in opinion. So that wasn't a case of racial fairness, but I think it's the same underlying feeling of being sensitive to the people before you. I remember when I was a sentencing judge, there was one sentencing case that sticks out in my mind that I know I made a huge difference. On the appellate courts, it's much harder. One person doesn't decide it, 2 people, and usually 3 people do. But again, there are rooms, and this unfortunate balls and strikes thing has obliterated the fact there's still room for discretion which can be objectively and fairly applied in a non-biased way, but in a way that recognizes the basic humanity and dignity of the people before you. And in those cases, you can make a difference. Also, the way the opinions are written. I've been able to write some opinions, which candidly they're overwritten, but they're written in a way to try to put into the literature, into the public discourse, information about subliminal bias and the role subliminal bias has. In one particular case comes to mind as a case overturning an injunction of a Philadelphia ordinance that precluded employers from considering wage history when setting wages for a new hire. I thought, a very enlightened and forward-looking ordinance. The district court partially enjoined that and was appealed, and that was a unanimous decision. So it wasn't just me. I didn't make a difference. A white judge, who was my counterpart in this situation, would have ruled the same way. We would have reinstated the ordinance. But the way the opinion was written, I think, went further because I was trying to educate folks about the role of subliminal bias and structural racism. And by allowing past wages to be brought into determining a present wage was doing nothing but perpetuating structural racism. So sometimes it can make a difference that way. But again, had there been controlling precedents to the contrary, saying that such ordinances were not valid, I couldn't have done a darn thing about it. Or had there been a statute controlling that said such ordinances were not valid, I couldn't have done a darn thing about it. It just turned on whether or not it was a basic case looking at the parameters of legislative action, whether or not the city had the authority to enact such an ordinance without anything else layered on top of it, which gave me more leeway than I normally would have had. But normally I really don't think it does not make a difference. The visibility may make a difference. I think it helps for practitioners, particularly law students, and even high school students, to see a Black person as a judge. Because growing up, I didn't know any judges. I grew up in a small town in upstate New York. I did know one lawyer. He was the town drunk. So, and that was the only lawyer that I didn't know him well, but I knew he was the town drunk. He was also the town mayor, for that matter. But that was really the only lawyer that I knew. I didn't really know him well. And so that exposure, so that people growing up begin to identify with the fact that maybe they can go on the bench too. That's why Juvaria's mission is so important, and what she's doing is so very important. And I commend her again for what she's doing. It's huge. It's really huge.
Thank you so much, Judge. Appreciate that. And I loved your answer where you touched upon intersectionality, which is that, you, in using your voice as a judge on the bench, that you don't ever just look at things through a racial justice lens, but you look at workers' justice and immigrants' rights, and you try to, noticing and understanding that this movement for liberation and freedom, as Vincent talked about earlier, really requires this kind of intersectionality. And with that, I'd love to ask Alexis what your thoughts are on the intersection specifically between, some of your civil rights work and racial justice work, which are, sometimes considered one in the same, and your journey in this space, and whether you think current civil rights litigation is either progressing or regressing this pursuit of racial justice in this moment.
Yeah, I think all too often civil rights and racial justice, we kind of think of them in the same way. I kind of think in popular discourse, civil rights has become a shorthand for something related to Black people or Black communities or Black and Brown communities. When I think the truth of the matter is, when you look at a court docket, like the one Judge Mckee handles and you help him with, Salma, civil rights cases will cover a wide range of issues and affect a wide range of communities. And it's worth kind of, bearing that in mind. I think in terms of progress, again, I have trouble being optimistic about the federal courts right now. I can't lie. But, it's a space. And again, this is why Juvaria's work is so important, because it is a space where these issues are coming up, whether a bunch of civil rights litigators get together and say, like, I have a grand strategy and we're going to bring this case and then this case, over 10 years, to think back to what Thurgood Marshall and Charles Hamilton Houston and other people did at Howard decades and decades ago. Even if it's not born of a grand strategy, really important issues are coming up all the time, in appellate courts. And sometimes they're brought by very sophisticated civil rights lawyers who work in national organizations, and sometimes they're not. Sometimes they're brought up by somebody who's appearing pro se. And so, you really see a wide range of actors getting involved in these cases. And I think, one thing that I try to do in my work is to kind of, it's taken me maybe 20 years since starting law school to feel like making sure we're talking about race is important, even when you don't have race claims. So to give you an example, and also this is a state appellate project that I worked on, not a federal one. We had a case that was pending in the New Jersey Supreme Court about the Newark Civilian Complaint Review Board. And the Civilian Complaint Review Board is supposed to provide civilian oversight of the police department. And, it's one of those reforms that's kind of getting more discussion since George Floyd was killed last year. Newark's has been under discussion for many decades. And it was one of these things, it was like very kind of typical, I think, of a lot of appellate work, where by the time it was getting to the New Jersey Supreme Court, it had come to seem so technical and like, okay, we're just talking about whether this state statute allows for subpoena power for a local governmental body created by the city council. We're just talking about the authority of the attorney general to, regulate the sharing of internal affairs files. And it really kind of getting lost from the narrative was the fact that this was all born of struggle in the streets of Newark, mostly by Black and Brown people for decades who had been calling for a CCRB. And, perhaps similar to the MacArthur Justice Center amicus project that Juvaria mentioned earlier, we were kind of aiming to provide a voice that would really be honest about the role of race in this case and, in dealing with this issue. So we wanted to, take ourselves not just deep in the statute or take ourselves away from, that deep statutory interpretation and kind of remind everybody what was really at stake. And so I tend to find that to be something that's very, very important because I think it's all too easy to remember, as Judge Mckee said earlier, not every case is black and white. A lot of them are black and white, but a lot of them are not. And, remembering the context in which we're operating, I think is essential. So I try to call upon people to kind of make sure you're adding those voices in, maybe write amicus briefs in cases that are pending in the appellate courts, even if you're not a party, to really kind of bring that real world perspective that sometimes gets lost.
Thank you so much. Thank you so much, Alexis. Yeah, about, your comment on really infusing racial justice into work where there's space to do so that it's heightened in the consciousness as we do this work. And thank you so much. And we have a few questions. We have about 12 minutes left. I'm wondering, are the panelists all free to go for maybe another 5 minutes afterwards?
Yeah, I am.
Okay.
Yep.
Okay, great. And so then I think there's a question, I think maybe one for each of you, actually. I'd like to start with you, Juvaria. It's what can people of color do to become more involved in the appellate process? How do new lawyers hone their schools to be effective in appellate practice? I, for example, did not go to law school that had any appellate clinics, nor did it really drill the concept or idea of appellate work.
Yeah, the clinic point is a good one. And, our first program has been partnering with Howard's Law School to bring an appellate focus to their historic civil rights clinic, because just that reason, appellate clinics are such a great way to get substantive experience and exposure early on. But a lot of those clinics are concentrated at a handful of schools and tend to not be very diverse. And, as Alexis was saying, Howard has really incubated civil rights appellate advocacy. So it's I think more clinics and more opportunities like that would be really great at other schools. But for students who are interested even more broadly, even if your school doesn't have that type of clinic, I think there's a few things. One is don't be shy about making your interests known. I think appellate work is, often can feel intimidating. You don't see people who look like you in this space. It can feel hard to voice that that's something you're interested in, but be proactive. And, no one's going to be as good of an advocate for you as you are. So just being mindful of, even reaching out to folks who do appellate work, who do cases that look interesting to you. Even if it's a cold outreach, your network is so important. And often for students of color, especially for first generation, you're coming in without those networks. And so not being shy to reach out to folks and just ask if you can talk to them, because with appellate work in particular, it's a pretty insular bar, it's pretty small. So that can also be helpful. And I would say practice your writing every chance you get. That's such a fundamental skill. It's really going to make you stand out. So whether that's doing, judicial externships, clinics, any job you're at, seek out writing opportunities, get feedback. Don't be discouraged by the red lines you receive. I remember my first opinion I turned in for my judge. I was so confident, like, oh, this is the best thing ever written. And they just came back slashed. It was really helpful. It was humbling, but it was so helpful. And I think, trying to think about it as what can I learn and how can I be a better writer? And then, I think to the extent you can, understand the space that you're entering, that what I was mentioning earlier, just feeling very lost in law school. Don't be shy about asking for help, even if it's just navigating these spaces or thinking about how do I get from A to B. I always felt like, oh, it's such a stupid question. I'm so embarrassed to ask. Why would you know those things, right? I mean, don't be shy about asking. So those are some things to come to mind. Obviously, I would pitch the Appellate Project and say, you should definitely get involved with our programs. Our mentorship program is just wrapping up, but we'll have a new cycle starting in the fall. You'll, get paired with an appellate practitioner, and we do programming every month. Clerkship guidance, we do legal writing workshops, networking opportunities. We have fabulous judges like Judge Mckee come talk to you. Check out the appellateproject.org if you're interested in that.
Thank you so much. I'd like to echo all of that and definitely say, I know when I was handling a few appellate matters when I was at my law firm, and it was amazing when summer associates or junior associates would come to me saying, hey, how can I get involved and take a chunk of this writing? And it was wonderful. And now I'm doing an appellate clerkship a little later in my career. And I just wish I did it earlier, because I'm learning so much every day from Judge Mckee and the types of questions that he asks and what he, and I just wish I knew this earlier in the game, but so judicial externships totally, and Judge Mckee works with clerks and externs and it's been amazing learning from the externs as well and their writing and vice versa. So definitely, thank you so much, and thanks, Judge, for teaching so many of us.
Oh,
It's part
you're
of
welcome.
I appreciate you, and there's this question is for you, Judge. How often do you see people of color perform oral arguments? What do you suggest needs to happen in order to get POC best prepared to enter into appellate practice?
It is so rare. I had an argument this week, and one of the attorneys was, I'll call her sister, a female from a big firm who I did not know. And I was thinking, how the hell did I not know this person was out there? But she wasn't from the Philadelphia legal community. And that was the first time I've had a person of color arguing, Jesus, I want to say in a couple of years. That might be an overstatement. I don't think it is. It's so rare.
That's
that when-
horrible. I just have to jump in and say that. It's horrible. A couple of years.
It is so rare that when you see a Black attorney at counsel table, my first thought is, who is this person? Write down the name. Say, how did I know that? How do I not know that person? I mean, it registers. It absolutely registers. It's very, very, very rare. This person was with a large firm. I'd like to say that when we see Black counsel on appeals, I would not like to say rather that it's more likely to be a criminal case. But even in criminal cases, be it the U.S. Attorney's Office or Defender's Office or a CJA panel, very, very, very rare that I've seen a Black or a Latino or Muslim attorney. The last time I saw someone who I could recognize as being a Muslim or Islamic, I can't remember. I remember a kind of a moot court exercise I was in up at Harvard many, many years ago. And there's a very prominent um, Islamic professor from Yale who argued. That's the first and last time I can remember. I may be forgetting someone. I don't think I am. And that was maybe 12 years ago.
Okay.
Very, very rare, very rare. And that goes back to what I was saying earlier about Juvaria's project and the importance of it and the need for folks to get involved and to begin not taking ourselves out of the mix. I have time to tell a really quick story. Years ago, I was at a panel with a judge who was a retired district court judge who had been asked by a U.S. senator to chair that senator's selection committee for judges, people to be vetted for and forwarded to the judge, for the senator for district court consideration. And that judge was specifically told by the senator, I want a diverse group of candidates. I don't want you just sending me all white males. In order to do that, you're going to have to get on the phone, contact the affinity bars, and recruit a diverse pool that you can then get to apply. And the judge then said that her experience was that every time she called a Latino or a Black possible applicant, the reaction was always, you sure you got the right person? You sure you got the right Tom Sullivan or Ted McKee or Vincent Sutherland? How'd you get my name? Who told you to call me? Whenever she called, with few exceptions, whenever she called a white person whose name had been forwarded to her, the response was, you know, it's interesting you'd call me. I've seriously been considering submitting my name to the commission. I've always wanted to go on the federal bench since I been practicing law, and yeah, I would be absolutely happy to. How can I get the questionnaire? She said without exception, and it so showed her, and she's white, the judge is, so showed her the discrepancies out there. One of my friends who teaches at NYU, a Black male professor, told me years ago when I was talking to this is a white female who did not think that she was circuit clerk material. I'm looking at a transcript and her resume and her credentials, and I'm saying to her, how in the world do you not see yourself as being competitive? Doesn't mean you're going to get a clerkship on the circuit, but you're certainly competitive. And I called the person, my friend who recommended her, and I told him that I don't understand why this person does not see herself as being competitive. And he said, you know, Judge, one of my goals here at NYU is to try to get white females and Latinos and Blacks to see themselves as being as competent as your typical mediocre white male sees himself or as being. it is so true. I mean, the difference in how we see ourselves, Malcolm said years ago, the worst thing that society has done to Black folks is to teach us to hate ourselves. And I think that's so true. And I think the gender part is that too. Women have been taught for years that they really shouldn't even think about these kinds of roles. And that's something that it's pathetic. It's part of the structural problem too.
Thanks, Judge. Thank you so much for sharing. And, this question is for you, Vincent. It's a very important question, something that a lot of activists that are trying to navigate both the spaces of being a litigator and this kind of what is seen as a neutral, unbiased justice system of arbitration, but also to be an activist with viewpoints, something that many people have been wondering. What is the role and impact? What role and impact do you think progressive grassroots movements, racial justice movements have on creating positive judicial precedent to further racial justice? What is the role of attorneys in working with movements in grassroots communities striving for racial, social, economic, and constitutional justice? How important is it to the judiciary and for impact litigation work? How important is it to you all to work with and center these movements, as often lawyers can center themselves in such movement work by putting forward arcane legal strategies over the calls for creative, newer strategies called upon by movements? And I think Alexis and Vincent, both of you could answer this.
Sure, and it's a phenomenal question, and I think in some ways the answer is almost suggested by the last part of the question, which is my personal view is that in order to kind of advance positive social and racial justice change, in some ways, lawyers have to take their cues, I think, from the communities who are going to be the most harmed, most impacted, and have the most kind of relevant experience with respect to those types of harms. And I think, in many ways, we're taught as lawyers to kind of come in and try and solve or direct whatever is happening and resolve the problem. But I think really kind of the best role that lawyers can play is in service of and alongside social movements, rather than kind of co-opting or being directive. And there are plenty of roles that lawyers can play with respect to those types of movements. You need lawyers who are going to be able to stand up in court when people have been arrested for civil disobedience, to defend people and help them get out of jail. You need lawyers who are going to be able to help social movements create 501c3s in order to advance advocacy in that way. You need lawyers who are going to be able to advance legal principles that are going to be in service of social movements. And so I think, to my mind, those movements have to be kind of at the center of a lot of these efforts, and lawyers have to be willing to kind of subvert their own ego and serve those movements and work alongside those movements. And I think the other piece of this is that the other part of the question is like how much have social movements done in order to kind of advance justice with respect to the courts. My view is really that law and culture are so deeply intertwined that it's often the case that law follows culture and cultural and social movements. And so I think a lot of those social movements help change the calculus of what's in the interest of the powerful and what's in the interests of those who are making decisions about the ways in which the law should operate. And by really highlighting the most significant harms that so many communities see and feel along racial lines, along gender lines, along lines of class, those movements have a really important role to play in terms of leveraging those experiences and really helping people see the world in a different light, and shaping opinions and worldviews and viewpoints. And I think we'd be remiss to think that judges and decision makers are not influenced by the things they see in the world around them. And social movements and social justice movements are, of course, shaping that world day in and day out. And I don't think there's been any change in this country that's ever happened in the absence of large-scale, broad-based social movements, whether it's the civil rights movement, whether it's movements for women's rights, movements along a whole host of other racial justice lines. They've always been anchored by social movements and movements of people, because ultimately that's what the law is about: relationships of people and power. And so I think it's essential that we take our cues from those movements.
I agree with that. Let me just add to that a word of caution. It's really exciting for folks involved in the movement to latch on to new revolutionary legal arguments as opposed to relying upon what's been labeled as the arcane approach, the arcane laws. Judges are incredibly reluctant. When you say, Your Honor, I invite you to make new law, that's an invitation you're not going to get an RSVP to. That is not going to get accepted, because judges are really conservative folks, always looking for precedent. It's good when common sense is consistent with precedent, but precedent controls. So to the extent that you can base the argument upon the so-called arcane legal approach, do that. And if you want to add a footnote as to some more novel approach that'll give the judge an alternative, fine. And I used that Charles Hamilton Houston and Thurgood Marshall, and what they did was not immediately start saying that separate but equal is inherently unconstitutional. They forced courts to look at the Black facilities and the white facilities, which are usually a goddamn joke in terms of any semblance of parity, and say, if you're going to have separate facilities, they have got to be equal, as you said in Plessy versus Ferguson. And over time, even though the racist institutions tried to make the separate facility equal, they didn't try all that hard. And financially, they couldn't try that hard, but they used that approach and pointer in a whole number of cases. So they finally got to the point of being able to make the argument that separate is inherently unequal. But that was built upon a bed of saying separate but equal is the law of the land. But if you look at Exhibit A, which is the white facility, Exhibit B, which is the Black facility, this is not equal. So enter an order to make them equal, not make an order to strike down the distinctions, but or to have one facility, but enter an order to make them equal. So be really careful about relying too much upon novel or revolutionary theories. Another person I'll mention just because not enough people know about her, Pauli Murray, Pauli, is an amazing individual. She was a transgender woman, I guess is the best, fairest way to label her. And she took the equal rights provision of the 14th Amendment and she used that in a way to get the courts eventually to apply it to females and take it out of the context that was enacted in of just race. In fact, Justice Ginsburg dedicated um, her book to her, and she credited, I think it's Ryder versus Ryder, and the academicians who would know better than me, the case where the Supreme Court finally said that the equal protection guarantees of the 14th Amendment apply equally to gender. It was Pauli's argument that was the lead impetus for that in the arguments that Ruth Bader Ginsburg did as a litigator. So just in terms of litigation strategy, be very, very careful about the argument, which is really fun and exciting and novel, and that which is boring as hell, because judges are going to be latching on to the argument, which is boring as hell, and going to be usually, not always, but deterred from getting into or very apprehensive about getting into new and novel or revolutionary certainly arguments.
Yeah, yeah. And I also want to say, I mean, I couldn't agree more with what Judge Mckee just said. And I think the other thing that lawyers can do, if you're that closely tied to movements, is you can almost leverage what a movement is pushing for, before a court, like say, okay, judge, here's what these folks want to do. Here's what I'm asking you to do, just as a matter of what precedent already says and what the law says, and find a way to kind of find the middle ground. You're still serving the ends of what the movement wants to have happen, but you're not kind of cutting off all opportunity for advancing the law by making arguments that no one is going to accept or listen to. So I think there's really kind of, a need to be strategic in your thinking and advocacy in all these ways. I couldn't agree more with what Judge just said.
Thank you both so much. And I know we have to end the conversation now. I'm not sure if each of the panelists, and I'll start with Alexis, I know you have to run and get the babies, but if you have any questions on or observations on the future of racial justice law and navigating it, really, you've given so much advice, all of you, and experience of what the landscape looks like and calls for, but any aspirations for the future or predictions that you'd like us to share and for all of us to keep in mind?
I think I'll just say quickly that, and I apologize for being near the lawnmower outside. I am feeling a little bit of hope right now, even though the courts have certainly taken a rightward turn, the federal courts. I do feel hopeful that so many people took to the streets last year after George Floyd's killing, and it really seems to have impacted the discourse. Now, it is plausible that I'm in my bubble of a lefty town in suburban New Jersey where everyone thinks like me, but I'm trying to be hopeful about the rest of the country too, maybe even the rest of the world. So I think if we continue to be thoughtful about the kinds of cases that we bring and the kind of cases that we take, there's a real chance for forward movement. And with that, I'm sorry to say I'm going to have to run, but
thank you so
much for having me. Great to see you all.
Alexis, we'll be in touch. Take care.
Take care. Thanks. Juvaria, I'd love your thoughts.
I would just say one thing that gives me hope is a lot of the students that I work with through the Appellate Project, they are very, feel very empowered to bring their full selves into these spaces and very thoughtful about that and what that means. And also have a lower tolerance for a lot of the stuff that, has long been held as assumptions of how these spaces operate. And so I think I love that energy and that passion. And if that's the future of the profession, that's a very good sign.
Thank you so much. Vincent?
I guess if we're thinking about things that make us hopeful, I think I'll have to borrow Alexis's answer and Juvaria's answer. I mean, I think the kind kind of uprisings from last summer and last year, and kind of what seemed to be an awakening of consciousness among a lot of folks gave me a lot of hope. I think seeing law students and young people who are engaged in these fights also gives me a lot of hope. And I also, recognize that this is a very, very much a long-term battle that has been ongoing and been waged for, centuries now in this country. And it's, I think we have to look at this fight as a long-term relay race where you do as much work within the time that you have, and you pass the baton on to those who are going to be following and continuing that battle forward. And the reality is that we're always going to see kind of this ebb and flow of progress and retrenchment. And the work for us is to see more progress in our lifetimes than retrenchment. And that takes, being hopeful, it takes being courageous, it takes being strategic. And it also requires you're kind of proximate to both the issues and concerns around racial justice and the communities that you're serving, and being steeled by all those who've come before you. My colleague Deborah Archer says that we are our ancestors' wildest dreams, and I think that's absolutely true. I don't think there's any. I know none of my ancestors would dream dream that I was where I am. I'm sure that's true for many of us, and so I think you have to take stock in that we stand on the shoulders of so many who've come before us. And they survived with far, far less and far more to face and thrive, in fact. So those are the things that give me some measure of hope.
Thank you so much. And speaking of ancestors and, passing the baton, Judge Mckee, I know you've been thinking about retirement for some time. And you are just.
No.
I know. So Judge, please share with us, your final words of wisdom for the future of racial justice, particularly in appellate work, and with all of your decades of experience, just any final words you can share, we will benefit from.
Well, I'll leave it on a real downer. I am incredibly pessimistic, really pessimistic. And I do agree that I remember the song, can't remember the title of it. I believe the children are the future, teach them well and they will lead the way. I think that's true. But I'm reminded when I think about that, the old thing about the frog who is 1 foot away from a wall and he jumps, and every time he jumps half the remaining distance. And the question is, how long will it take the frog to reach the wall? And the answer is never, because he never makes that final hump. Vincent's right. We are our ancestors' wildest dreams. Both my great grandmother and great grandfather were born into slavery. They were 17 when they found out that they had been freed. I think they were about 15 when they actually were freed, but 2 years later they found out about it. Having said that about the children, I'm thinking of David Habersham's book, The Children. That was written about a generation of folks who were, I guess, in their college age. And those kids are now the age that I am now, and we're still having the same discussion. And I don't think real change will be made until the country faces its future. And I don't see that happening. The idea of a Truth and Reconciliation Commission here, that's what we need. I don't see it happening. South Africa was able to do it, and you could argue that South Africa, there was such a much stronger systematic and structural racism in place than here, and they did it, which is true. I don't see any Nelson Mandelas on the horizon in the United States of America of any race. I just don't see it happening. We're still debating whether or not statutes honoring slaveholders should be taken down from the public square. I mean, if that's the level of the discourse, we got a hell of a long way to go. We just don't admit what the country is about. Several years ago, there was a push in one state to try to make the teaching of history. And there was pushback because people in Congress were saying that they were teaching hate because they wanted to inform folks that the Constitution was written by folks who owned slaves, and the debate during the time of the Constitution about whether or not it was a pro-slavery document or anti-slavery document, which was not at all clear at the time. And if you read it, it sure reads like a pro-slavery document, since the only provision in the Constitution which says this provision shall not be amended was a provision dealing with slavery. The founders said you can't touch that provision protecting slavery. So I guess I wound up by saying I'm pessimistic, which is not the reason to just not try, because we got to get up in the morning, got to get out of bed in the morning. So it makes sense to me to continue to try. And there is incremental progress, like the frog jumping toward the wall. So I don't want to surrender it. And every now and then there's a case that comes along in my own world, like the woman who's trying to get black lung benefits, survivors benefits, where a difference can be made. And I kind of look at that as my dues. And that's what I have to do to justify my being there and to make it all worthwhile. There's a starfish story, which I'm reminded of. I won't go into now, it takes too long, but if folks can Google the starfish story, that kind of says it all, where you look down at the one starfish you saved and you say, I made a difference through that one. And I think that's what keeps me going. I think it's what keeps a lot of folks going. Now, Salma, I hope I have not totally bummed you out. You're
No,
looking back at this year and saying, Jesus, why the hell did I ever work with that guy? He totally destroyed any hope I ever had in my life.
no, you're challenging us in a very realistic way, and you know, you've made such a difference in so many people's lives, as is all the panelists here. So thank you all so much for your time and your energy and your commitment and this conversation, and to really push us all to think a little bit more strategically about some of these issues and some of this work. And I'll just end with a quote by Thurgood Marshall that he said during his acceptance speech to the Liberty Award at the National Constitution Center. And it said, I wish I could say that racism and prejudice were only distant memories. We must dissent from the indifference. We must dissent from the apathy. We must dissent from the fear, the hatred, and the mistrust. We must dissent because America can do better and because America has no choice but to do better. And so I think that wraps it up, that, you know, we will, like Judge was saying, and the frog leaping, racism will never be eradicated in this country, but we can keep trying to make those leaps, and we have to keep dissenting and keep trying, because we have a moral obligation, I guess, as US citizens to do so, and to help those in our neighbors. And so thank you all so much for your time today, and I'll send everybody the recording, and all those who weren't able to attend but registered to attend, I'll send them as well. And thank you all so much, and I hope you have a wonderful day.
Thank you.
Thank you, Salma. Take care.
It's a great seeing you. Take care.
Great seeing you
Sorry,
too,
same
Judge.
thing. Good seeing you.
Take
Salma, I'll
care,
see you
Juvaria.
tomorrow.
Okay, see you tomorrow, Judge.
Okay, take care. All right, bye-bye.
Take care, everybody.